Henshaw here again, Constitutional Crisis Channel. And this is more or less current events, although these events haven't happened yet. But this is where I'm headed and where I think we should all be headed. And that is that I'll be going real soon to my local court here, a quote-unquote state court. It pretends to be one, but it isn't. And I'm going to attempt to file documents there in a federal circuit court. Concurrent federal jurisdiction. It's existed for 225 years. You can look it up in Federalist Papers No. 82, written by that bastard Hamilton, but for once he was right. I mean, he was a much better liar than Bill Clinton ever was, trust me. But in this case, he was right. Jurisdiction exists, and it exists what's legally called exproprio vigere, which means it doesn't need any acts of Congress. It doesn't need any acts of the state legislature. Those judicial courts have to be there, because if they're not, then we don't have access to any judicial courts, and effectively you've done away with at least Article 1, Section 9 and 10 of the Constitution for the United States. And that can't be possible. And you may think, well, I'm crazy. I'm not crazy. The Supreme Court has held that Congress has no constitutionally mandated duty to create lower federal courts. Case there is Cary, C-A-R-Y, versus Curtis, C-U-R-T-I-S, 3 Howard 235, 1842, I believe. And they said right in there, and if you read that case, read the dissent of Justice Joseph Story. That's one of the best things I have ever seen written. And he said, wait a minute, because he had held in an earlier case called Martin v. Hunter-Leslie, just the opposite. Cary, in effect, reversed Martin. But the only way they could do that, and this I don't think is in either part of the Cary opinion, either his dissent or the main opinion, is about the fact that there are no judicial courts. And if that's the case, then we have to be able to get into a state court with concurrent jurisdiction. A big case on this subject, by the way, is called Claflin, C-L-A-F-L-I-N, versus Houseman, H-O-U-S-M-A-N, 93 U.S. 130. These courts are there. They have to be there. Otherwise, there's no judicial process, and every law passed by Congress or your friendly local state legislature is a bill of attainder. Simple as that. So I'm going to be going down there, and I've already notified everyone in charge at my local courthouse. I'm coming, and here's why, here's the law. Instruct your subordinates that when I come, they know who the hell I am and what I'm doing, and get out of my way. If that doesn't happen, I'm going down there with a witness or two, and I'm going to have right with me so the clerk can see it. Federal criminal complaint addressed to the United States Attorney here. And I'm going to be filing against the clerk, and I'm going to ask the U.S. Attorney to arrest them for treason to the Constitution for not doing their job. This is how we get going here, and we get our rights involved. And the good news here, with the change in administration and with Jeff Sessions coming in as the Attorney General, which looks likely, and with Neil Gorsuch appointed to the Supreme Court, these are movements in the right direction for these kind of issues. They will be taken much more seriously than they got taken by Loretta French and that idiot Eric No Holder in due course, and going all the way back to Ed Mouse in 1988. Now we got somebody in the Attorney General's office that may actually see the light of day there. And this is the way they get there, because how many people are you going to think end up in jail for not doing their jobs? How many will it take for them to get the idea that they have to obey their oath of office and file the documents without any filing fees, without any state forms, none of that? It's our own court, and we make the rules, otherwise known as the Constitution for the United States. And this is where I'm headed, and if this succeeds, the ball game is over. Once we get into our own courts, where they recognize our status, standing, and creator-endowed inalienable rights, now we have the forum in which these questions will get answered either by a jury and or the Supreme Court of the United States. And the latter, by the way, has the sworn duty to decide these things. And if you don't think that's true, take a look at the case of Cohens against State of Virginia, 19 U.S. 264, where Chief Justice Marshall said as much, that we had a right to present our case to the court of the nation. It's amazing stuff. But when I read that in the libraries, law library 30 odd years ago, I broke down in tears, which is not normally what you expect to do in those musty old, books of law and stuff like that. But we have a right. One person can make a difference. This is the only nation that's ever been created that way where that's possible. And I want to keep that alive more than anything. I can do it. I can teach you to do it. And the more of us that do it, the sooner we're going to get these bastards out of there and get back the government we're supposed to have. Thank you.